My guest at this time is Rob Henneke. He's the General Counsel and Director of the Center for the American Future at the Texas Public Policy Foundation. Rob is the attorney for the individual plaintiffs currently suing to have the courts declare Obamacare unconstitutional now that there is no tax penalty for not purchasing health insurance, the rationale that Chief Justice John Roberts used to keep Obamacare alive in the 2012 Supreme Court decision. On Wednesday, the Fifth Circuit Court of Appeals agreed, but the battle continues. And Rob, thanks so much for being with us.
My pleasure, Greg. It's great to be back with you.
Well, it's a 2-1 decision on a 3-judge panel in the Fifth Circuit. First of all, deciding that the states who are suing alongside of you, as well as the individual plaintiffs, have standing here, and they agree that without a tax penalty, the individual mandate is unconstitutional. What they seem to be unclear about, though, is whether the law can stand without the individual mandate, so they're sending it back to the original district court judge, which declared the whole thing unconstitutional. So what's your reaction to this decision?
Well, and interestingly enough, when the Fifth Circuit ordered the remand back to the trial court, it explicitly said, we're not prejudging your decision. We're not saying that we don't think that the entire Affordable Care Act could be struck down or not. We're just saying you didn't give enough explanation in your district court opinion to justify the decision you made to invalidate the entirety of the Affordable Care Act because of the unconstitutionality of the individual mandate. Now, Greg, it may be all an academic question because we already know that the California Attorney General announced yesterday that he intends to file a petition for review at the U.S. Supreme Court. California, of course, is leading the coalition to defend the Affordable Care Act. So we may be going first to the Supreme Court and may never end up back down at the trial court on this question.
Rob, what's your read if this case ultimately does get back before Justice Roberts? The thinking, of course, in originating this case is he's got to follow the logic he laid out in his 2012 decision, but he also mentioned in that majority opinion that it's not the job of the court to undo laws. If you want to do that, that's what elections are for, elect the people that agree with you. So it seems like he's reticent to overturn a major piece of legislation. A lot of folks, of course, on the right believe that he contorted himself to keep the law alive when he did back in 2012. So how do you expect him to approach this?
Well, if you in that lens, and I don't disagree with the way that you framed it, but if the Chief Justice is looking at that in that lens, then it's two tough decisions because, if you were to find a way to save the Affordable Care Act for the third time, then you're probably overruling your own precedent because the decision that we won yesterday was based squarely upon how the Supreme Court had ruled about the Affordable Care Act in the past. And so if the court's just willing to throw out its own opinions because it doesn't like now what that outcome would be, that would certainly question the legitimacy of the court. Of course, the court will get a lot of criticism if it follows the law and strikes down the Affordable Care Act. But I think the Chief Justice Roberts is moving in the direction of agreeing that the mandate cannot be severed from the entirety of the Affordable Care Act. This is a position that the 4 conservative judges at the time, back in 2012, agreed with, but the question of severability was not reached. But if you look at the second Obamacare case that the Supreme Court decided, which was the King versus Burwell case, and again, the case that Chief Justice Roberts wrote the majority opinion on, he's the one that described the individual mandate as the key component in the Affordable Care Act. He described the ACA as a 3-legged stool, with the individual mandate being one of the legs upon which the stool rested. So if you look at how he's treated this issue in the past, it would be consistent for him to agree that, Congress built the entire Affordable Care Act resting upon the pillar of the individual mandate, which is a true statement, and that without that individual mandate, the court has no choice but to allow the statute to fall and to require Congress to do its job to go back and adopt legislation that will actually pass constitutional scrutiny.
Let me get your reaction, Rob, to a couple of different arguments I've heard since this decision from the three-judge panel just came down on Wednesday, one from the left and one actually from the right, which you might find a little bit surprising. But the one from the left, of course, which you've heard before and I think we've even talked about before, is, well, look, if all of this comes down, there's a lot of people who have coverage now that didn't have it then, much of it on Medicaid, but not all. And if, in fact, this were to be completely torn down, all of those people are suddenly back left out on their own. What's your response to that?
You know, that criticism presumes that Congress and states and policymakers are tied up and shoved in the back of the trunk of an automobile while this case is pending, which is absurd. This was actually raised during argument at the Fifth Circuit, where the attorney for the House of Representatives was trying to make this very emotional case about all of these other provisions of the Affordable Care Act that were in jeopardy of being struck down. And during arguments, Judge Engelhardt was very direct in response to that attorney by saying, "Where has Congress been?" He said, you have known about the trial court decision for 8 months now, and your client, the House of Representatives, has not done anything to come back and pass these other, things that you're arguing about in standalone legislation or in legislation that would avoid this question of unconstitutionality. So, don't look at the courts to be the taxidermist for Congress, was a quote from Judge Engelhardt. And so I think it's very true that as much as those may decry the consequence of this case, what they should be looking to is not the judiciary in doing its job, which is to call balls and strikes and to review the legality and constitutionality of law. They should be looking at Nancy Pelosi and Mitch McConnell and governors across the nation to step up and adopt health care policy solutions that will be legal and will actually deliver upon the promises and the desires of the American people in terms of accessing health care.
But the bottom line, from what I think I hear you saying, is that while justices or judges, depending on the level, might care about the impact, ultimately if something's unconstitutional, it's not the court's job necessarily to figure out what the policy response to that decision needs to be.
That's right. We don't want judges writing law. We don't want activist judges. We want the judges to do their job and to evaluate the law before them. And we want to insist that our other elected officials in the other branches of government do their jobs that they were elected to do.
This next question is probably going to hit a little bit closer to home given who you're representing in this case with the plaintiffs who have standing here. But I heard from actually one conservative today wondering what's left to fight here. They say, well, the individual mandate is effectively dead because there's no penalty now for violating it. The medical device tax is gone. The Cadillac tax is about to be gone if the spending bill goes through this week. And some other things have been either modified or changed. Obviously, your clients and the states that are still fighting this believe there's a whole lot more suffering going on here as a result of this law. So what's your reaction to the idea that some of the worst elements have been addressed here, and so leaving Obamacare with what's left of it isn't as burdensome as it used to be?
I disagree. And first of all, the focus is on the damage caused by the individual mandate, not by the damage caused by a lack of the individual mandate penalty, which of course was repealed by Congress. But the injury to my clients who are, self-employed individuals, small, self-employed consultants, is that they are commanded to purchase this insurance, and the only source of insurance that they have under federal law is to acquire it through the Obamacare exchanges. And these insurance products that are incredibly expensive, that my clients do not want to purchase because it does not meet their needs for health care. And beyond the cost, my clients have testified in the record, and this never has been disputed, about negative consequences under these plans, such as not, losing the doctor of their choice when the ACA plan has put their personal doctor out of network, and also instances of rationing where you have healthcare providers now who are limiting how many appointments per week they're willing to take for people who are on these ACA plans. So the injuries continue for the millions of Americans whose access to health insurance is still through the Affordable Care Act, and for the millions of Americans who have been priced out of insurance because of the increasing cost that's been driven by the ACA and all of its regulations and red tape.
Real quickly, Rob, you said that California wants to take this straight to the Supremes. How soon do you think that could happen?
I expect that they're preparing the petition to ask the Supreme Court to grant review. If it wasn't for the upcoming holidays, it wouldn't surprise me if it was filed next week. But here in the next couple of weeks, for sure, I think that California will file their official petition, and that will start the process to seeing if the Supreme Court is willing to grant review at this point in time, or if not, then what's going to happen next.
The politicos want to know if they do accept it and agree to hear the case, will there be a verdict before Election Day?
Likely not. We are already late in the term for this Supreme Court, and so the most likely occurrence is that a cert petition to the Supreme Court would be granted but would not be set for argument until the fall of 2020, with a likely decision in 2021. So probably the most likely scenario given the calendar at this time.
Rob, last question. What's the reaction of your clients to what they've seen so far, especially Wednesday's decision at the Fifth Circuit?
My clients are very excited to have their day in court and to have affirmation of the win from last year at the trial court. That's speaking to their constitutional rights to not be commanded by the federal government to do something they don't want to in this. So they know it's not over, but they've been the ones that have been most directly impacted in this case by the Affordable Care Act. Yesterday was a historic win, and I know half my clients were excited to defend that at the next step, whatever that may be.
Rob, we'll be watching. You're always good to spend time with us as we chart the efforts that you and the attorneys general are making on this case. Thanks very much.
Greg, thanks. Great to be with you.
Thank you, sir. Rob Henneke, General Counsel and Director of the Center for the American Future at the Texas Public Policy Foundation. I'm Greg Columbus reporting for Radio America.